Hello everyone, and thank you for joining the Secrets Wordle My PIP Monthly July 2020 edition. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. For July 2020, I'm going to highlight a few cases that we believe are noteworthy beyond our typical newsletters. The first is going to be Tony Williams v. Nationwide Mutual Fire Insurance Company, issued June 4th, 2020. The next will be Richard Bears v. David Fanzini, issued June 18, 2020. Next will be J.F. Warren, LLC, DBA Newport Inn, and Jimmy A., LLC, the Main State Motors, Inc., DBA Reds Towing Service, and Eric Thomas Ferguson and Consolidated Insurance Company, issued June 25, 2020. And lastly, Johnson et al. V. State Farm Mutual Automobile Insurance Company, issued June 25, 2020. As for the trending topics in PIP litigation, I'll be discussing the accord and satisfaction defense and the requirements that need to be met to dispose of cases where accord and satisfaction have taken place. Tony Williams v. Nationwide Mutual Fire Insurance Company is an unpublished opinion from the Michigan Court of Appeals, issued June 4, 2020. Unpublished opinions are not binding, however, they may be considered by the court for their instructive or persuasive value. In Williams, the Court of Appeals affirmed the Wayne County Circuit Court's dismissal of plaintiff's complaint as plaintiff committed fraudulent insurance acts when she submitted false attendant care forms. Plaintiff Williams submitted forms that detailed almost 12 hours of attendant care being provided by her two daughters, approximately 6 hours each. The forms generally reflected that one of her daughters provided 8 hours of care from 6 to 2. The forms provided from this specific daughter are what is at issue in the instant matter. The daughter produced forms that indicated she provided 8 hours of care from 6 to 2. The forms also reflected the occasional 16 hours of care from 6 a.m. till 10 p.m. on the weekends. When this daughter was deposed, she testified that she was employed at the airport and worked from 2 p.m. to 8 p.m. daily. She also testified that while she had no set schedule regarding attendant care provided to her mother, she would provide care for her mother from 8 or 9 a.m. until approximately 11 a.m. or 12 p.m. noon. At that time, approximately 11 or 12 p.m., her mother would be picked up for her doctor's appointments. Obviously, this is inconsistent with the forms provided that indicated that she provided care almost daily from 6 a.m. to 2 p.m. Specifically, if the forms indicated that she provided care from 6 a.m. to 2 p.m., she couldn't have been at work at 6 p.m., and her mother also couldn't have attended her doctor's appointments almost daily beginning at 11 p.m. to 12 p.m. Additionally, 6 a.m. is a big difference from 8 or 9 a.m., which she testified to. As such, Judge Annette Berry of the Wayne County Circuit Court granted summary disposition in favor of defendant, reasoning that plaintiff submitted false information in support of her claim. The Court of Appeals affirmed. While Williams v. Nationwide specifically dealt with MCL 500-3173A, a statute pertaining to the Michigan Automobile Insurance Placement Facility, the courts used a similar analysis under Bari v. IDS Property Casual Insurance Company, wherein the court held that the fraud provision in an insurance contract could bar a claim for PIP benefits when the policyholder filed a claim for replacement services for a date prior to the subject accident. The difference between Williams and Bari is that in Williams, the MAIPF does not have an insurance contract with the insured, so they must rely on the statute as they did here. However, in Bari, there was a policy of insurance, so the fraud provision within the insurance contract is what controlled. The next case law update is the unpublished opinion of Richard Bears v. David Fanzini. Generally speaking, the driver of an automobile that is distracted by receiving or sending a text message is undoubtedly negligent. The sender of that text message is not typically liable for the driver's negligent actions. Here, the plaintiff argued that the defendant, who was not a passenger in the vehicle but was the sender of a text message, was negligent as he distracted the at-fault driver, who in turn caused the accident that injured plaintiff. Plaintiff further argued that defendant knew that the driver was actually driving at the time the text message was sent. Plaintiff alleged that the defendant had a duty to avoid distracting the driver, citing the case of Hurdle v. Chindom, 155 Mish App 582, 1986, which held that the passenger of an automobile owed a duty of reasonable care not to distract the driver. The plaintiff and Bears attempted to make the same argument, defining the defendant as an electronic passenger. Ultimately, the Court of Appeals rejected this argument and held that the defendant owed no duty to plaintiff. This is important because the court reasoned that when defendant sent the text message, it was not reasonably foreseeable that the at-fault driver would open it and read it at the exact time she was driving the car. As such, without a duty, there can be no negligence. Next, I wanted to discuss the case of J.F. Warren, LLC, DBA Newport Inn, and Jimmy A. LLC, the Mainstay Motors, Inc., DBA Red's Towing Service, and Eric Thomas Ferguson, the Consolidated Insurance Company, issued June 25, 2020. In this case, plaintiff claimed the actual cash value for an entire property, both the damaged and undamaged portions, after it was damaged by a tow truck driven by Eric Thomas Ferguson. Plaintiff here was unable to repair or rebuild the building after the accident because of a local ordinance requiring a greater setback from the road. As a result, the Newport Inn was unable to operate since the accident. Of note, plaintiff did not have ordinance insurance coverage, which would have covered the relocation of the building further from the road. Plaintiff sought replacement costs for their business income, diminution of property value, and property damage for the damages caused by defendant's insured's motor vehicle. The court disagreed. Under the no-fault statute and defendant's insurance policy, defendant was required to pay the lesser of either 1, the reasonable repair cost, or 2, the replacement cost less depreciation. Plaintiffs here did not deny that they received actual cash value for their damaged property. However, they did argue that they were entitled to the actual cash value for the entire property, both the damaged and undamaged portions. Plaintiffs did not cite any authority for this position, so the court did not consider the issue. Regardless, MCL 500-3121 Section 1 states that the insurer is required to pay only for the property that is damaged by a motor vehicle. Damage to tangible property consists of physical injury to or destruction of the property and the loss of the use of the property so injured or destroyed. Plaintiff's second argument in this case concerned loss of use, claiming it was not limited to damages for lost profits. The court again disagreed. Finally, the court held that neither plaintiff presented specific facts to establish a claim for lost profits to be considered by a jury. Newport Inn's tax return showed that the business lost money rather than made money for the years of 2012 through 2016. The only evidence submitted by Newport to demonstrate that it was a profitable business was an unsworn letter from an accountant which failed to actually state that the business was profitable. Jimmy A. failed to put forth any proof showing that it was a profitable business also. Thus, the court determined that the mere pledge by the accountant was speculative at best and not enough to survive a motion for summary disposition. Lastly, I wanted to discuss Johnson et al. V. State Farm Mutual Automobile Insurance Company, issued June 25, 2020. This is also an unpublished opinion that highlights the importance of defining terms within a policy of insurance if a certain definition is desired. While riding his moped, 13-year-old Keyshawn Johnson was struck by an uninsured vehicle, resulting in serious injuries. At the time of the accident, Keyshawn was living with Sandria Blakely, whose personal automobile was insured by State Farm. Following the accident, on behalf of Keyshawn, Ms. Blakely presented a claim for uninsured motorist benefits. State Farm denied the claim by indicating that it was excluded from coverage due to their policy indicating that there is no coverage for an insured who sustains bodily injury while occupying a motor vehicle or motorcycle owned by the insured or any resident relative if it is not the insured's car or a newly acquired car. Here, the parties disagreed on whether the moped was actually a motor vehicle for purposes of the UM coverage. The failure to define the term motor vehicle for the purposes of the exclusion was sufficient to create the ambiguity necessary to find in favor of affording coverage. As we know, exclusions are to be construed strictly in favor of the insured. Therefore, insurers should practice consistency throughout their policy forms to ensure no ambiguity can be found. Moving on to trending topics in PIP litigation. This month we wanted to discuss the accord and satisfaction defense. An accord and satisfaction is an affirmative defense grounded in contract principles. An accord and satisfaction requires the meeting of the minds of those who enter into it. A satisfaction is the discharge of a debt occurring after acceptance of the accord. The accord and satisfaction defense typically pops up when a medical provider periodically bills an insurer. The insurer then pays each of the provider's bills in accordance with its reasonable and customary review of the services rendered. Each claim that the insurer pays includes an explanation of a review, which explains the dispute with the debt and the total amount to be paid by the insurer. The provider then cashes all of these checks, and prior to the insurer's tender, provider did not designate any person to receive instruments tendered in full satisfaction of the claim. What happens next is that after the provider cashes the checks, the provider then demands the difference between the amounts it initially billed on each claim and the amount that the insurer paid. In order to claim this defense, it must somehow be shown that the provider is put on notice that the insurer intends for that payment, that original check, to be payment of a full satisfaction of the amount submitted, and the provider is aware of this intention. The provider also must not tender any amount back to the insurer at any time for you to claim this defense. If all of this has happened, and of course this does not encompass every situation in which accord and satisfaction can be used as a defense, but we've seen a lot of provider cases as well as PIP cases where the plaintiff is claiming the provider bills where this has been an issue. But nevertheless, if this set of facts sound familiar, the provider cannot collect any amounts over what the insurer has paid. This defense is based upon MCL 440-331. Pursuant to MCL 440-331, a provider cannot collect any amounts over what the insured has paid because insured tendered a negotiable instrument in good faith and in full satisfaction of the claim. Also, the provider's claims were unliquidated or subject to a bona fide factual dispute. The provider negotiated the checks by depositing or cashing them, and either of the following apply. The provider must have had actual knowledge of that the insurer's payment was intended to be a full satisfaction of the debt, or the insurer accompanied each payment with correspondence, typically an explanation of review that clearly and conspicuously indicated that the payment was intended as full satisfaction of the claim. In most cases, both of the last prong D, are satisfied by the explanation of review, which typically indicate that it is intended to be full satisfaction of the debt. By way of background, common law accord and satisfaction decisions fell along two lines of cases. The first type of case held that whether there was a sufficient meeting of the minds for an accord and satisfaction was a question of the jury. The second holds that the required meeting of the minds is implied as a matter of law by the acceptance of the offer. The fact that the recipient altered or crossed out the accord is irrelevant. Generally, what this is referring to is the memo line on a check. Sometimes what a provider or medical facility does when they receive the payment is attempt to cross out what has been indicated in the memo line of the check, which would typically indicate that it was in full satisfaction of the debt or something along those lines. So what this is saying that even if that is altered or crossed out, it's irrelevant. And you can still claim the accord and satisfaction defense, even if that is the case. When the legislator enacted MCL 440 Section 3311, it followed the second line of cases. This effectively repudiates any application of the first line of cases to accord and satisfaction involving negotiable instruments, leaving MCL 440 Section 3311 to control all accord and satisfactions involving negotiable instruments. Now, I want to go back. Briefly, I talked about every element that needed to be satisfied in order to claim this as a defense. I want to talk about those more in detail and what it takes to completely satisfy these elements. So the first requirement of an according satisfaction is the good faith tender to the claimant as full satisfaction of the claim. Good faith is defined as honesty in fact and the observance of reasonable commercial standards of fair dealing. Typically, honesty in offering checks is reflected in an accompanying explanation of review, which generally state, unless otherwise noted, all bill review reductions are due to charges exceeding amounts that would appear reasonable for the provider's geographical region. Then the provider must cash the checks, and given that tenders were made in such detail and with clear explanations of the reasoning, there's no doubt that they have satisfied the good faith requirement. The second requirement of an accordant satisfaction involving a negotiable instrument is that the claim be unliquidated or subject to a bona fide dispute. The third requirement is that the claimant must obtain payment of the instrument. This requirement is easily satisfied when the provider deposits the checks or cashes the checks. Once the first three requirements are satisfied, the question becomes whether the claim was discharged. Under the statute, there are two ways to discharge a claim. The first is when the claim is accompanied with written communication that contains a statement that the tender is in full satisfaction of the claim. Second, the claim is discharged if the claimant or claimant's agent was aware that the tendered amount was in full or was intended to be in full satisfaction of the claim. If you have any questions about the case law updates or the accordant satisfaction defense, please feel free to contact me. Again, this is Amber Rouse Holloway, partner here at Secrets Wardle in Troy. We appreciate you tuning in to My PIP Monthly.